Hello, hello, hello. Can I get someone to tell me what the volume's like? See if it's okay. Did you get two notifications, student? That would be great because others are telling me that YouTube notifications did not go out 30 minutes ago. Hopefully, you can hear me okay. All the everything's all set up. We've been having some issues. Thank you, Shill. Hey, Rocket Couch. Okay. Um, thank you for everybody who's here already. I'm glad to see some mods. I know I was made it a little bit of. Nope, you're cracking me up, Nippet. I like had to double take there. Like, okay. Um, yeah. Yeah, I haven't been back long. Thank you, everybody, for the warm welcome back on Sunday. Those of you that were there, it was nice to connect with everyone and talk again. As you can hear, my voice is like, but I'm gonna struggle through because damn, boo boo Boone, our little friend Sarah Boone, you know, she been very busy, very busy. Yeah. Hey, Sean. Hey, Fishner. Hello, everybody in chat. Mousy, student, Shield, thank you for being here. Liam, thank you for being here. You know, for modding, Mippet, student, it's good to see you. Rocket Couch, everybody. If I've missed anybody, I apologize. And to everybody coming in, I'm not going to be stopping to greet everybody, but I am very pleased when you come. I do know there's a problem with the Twitter feed. It's not live on Twitter. It failed again when I tried to set it up. I think I'm going to have to reset up all of the permissions and before we can go back on Twitter with the live. So we'll just have this one in replay, and that's all just fine. That's all just fine. You know, it is what it is, right? Yeah. So today we're going to be talking about Sarah Boone. Yeah. And I know you guys just can't wait, right? Yes. Sarah Boone has been very busy. Last time we talked, it was right before the Judge Kranick, Saint Kranick, you know, he's soon to be nominated, I'm sure, especially after the last two hearings. Okay. Um, Short story, we had two hearings, August 5th, August 9th. Uh, since she's been pro se, the last time we talked, there was a July 22nd cutoff for motions. Sarah was aware of that, and she did write quite a few motions, and she did mail them. The court did not get them till the 28th of July, but they were dated for the 18th, and so everything was put through. The first thing I'd like to say is that Sarah is getting a lot of cooperation and help from as many different parts of the court system that she can. I mean, Judge Kranick is doing his best to keep this on track and going. But because it's Sarah Boone, there are quite a few issues. Okay. I don't know how many of you have watched any of the hearings or any of the other videos that, you know, LawTube or even commentary channels have put out on Sarah Boone in the last 2 weeks while I was gone. But it's been a lot. I mean, she waffles between I don't know what's going on and then sends out 6, 7 well written and well documented motions. Um yeah, like I don't know. I got a lot to say, and it's not just me. Like I researched it a little bit to find out if, like, well, maybe I'm just tired of Sarah Boone, you know, because it has been quite a long time, you know. It has been quite a long time. She's been there almost 5 years, you know, in waiting for this trial, you know. It is still scheduled for October 7th, by the way. So, oh, you know what, you know, I can't disagree with either of you or Fish Nerd as says, is Sarah herself an issue? Yeah, I'll leave it up to you guys to decide. But basically, with all the information I'm going to put out tonight, I'll give you enough to go by, or we'll see. And some other sources too, not just me. Okay. And oh, she is a manipulative git. Well, she's manipulative. She very well is. Hey, Brody. Oh, thank you very much for being here. Well, let's get started with Sarah. Okay, we know she went pro se. Before I start bringing up what happened in the hearings, we know that the judge issued a 16-page. order as to why she has forfeited all rights to a paid attorney on behalf of the state. That it was her actions. He documented every time she was told, every instance of attorney. Okay. And the reason I'm bringing this up is because, well, as you will see in the rest of the presentation that I have, Sarah just won't stop. Sarah is offended that the judge didn't personally talk to her about every single reason that she didn't get along with an attorney, and she should have had an evidentiary hearing. Okay, that has been addressed. The first bunch of motions that went out, the first 5 that went out, let me just get with it here. Okay, the first 5 that actually went out, Sarah, Sarah, oh God, I gotta get away. I know my whole thing is out of order. All right, let me just go back to this one then. All right, the first 5 that she addressed were she was going to first say she wanted money to depose witnesses, to find witnesses, and she needed the money to do that. And she filed a motion on that. She filed a motion for a private investigator. She filed a motion to get all of her discovery, very long, claiming she's never seen a thing, ever, at all. Okay. She also then filed a motion that she wanted standby counsel. Mm-hmm. Yeah, you heard me. Yep, she had the nerve to ask for standby counsel. Now, that's going to bring us to the motions. Okay, let me just bring myself up there since that was all out of order. We'll just talk about the first one. Sarah sent in a motion. We all know that the JAC, when you're an indigent, as Sarah has been declared indigent, and she has certain rights to get certain things paid for under the JAC's understanding on how things get submitted. So, in her August 5th hearing, first of all, she was brought and told all these pro se stuff. She was very upset that she was brought before the judge without any advance notice to be told that she's now pro se. JAC was there, everybody was there, and they were going to discuss this whole thing. She was actually told by JAC, that they would the judge understood that she was now pro se, but that she could still file for things. They were there. The judge laid everything out to her. Sarah's pretending that never happened. Okay. She filed all of these motions knowing that the deadline was July 22nd. That was announced in that hearing to her. She was told about the pro se. She was told what was going to happen. She was told that she had a right to her evidence in discovery and that it would be given to her, but that he needed the judge, he being the judge, Judge Michael Kranick, needed to speak to the prison into how to handle that, because he has no control. The judge is not allowed to look at that discovery or that evidence. He's not allowed to handle it. He needs to just make arrangements for her to have it, but he has no vehicle to do that. He needs to deal with the prison to do that. And they have certain rules and regulations. And that is what has been going on for quite a few weeks now, since we last talked about Sarah Boone. And we talked about Sarah a lot before I left on my little break. She definitely wanes back and forth between I understand and I don't. And that's one thing that's I've noticed is Shara says, I understand a lot. And then proceeds to ask the same question again and again and again until she gets the answer she wants, I guess. Well, I'm happy to report that Judge Kranick seems to be very aware of this now. And he has changed his style with her completely. Although he's being very cooperative, he's also dotting all the I's and crossing all the T's. And he's in total legal mode. And he's protecting this case. He's protecting the validity of this trial. He's protecting the fairness of it on both sides. He is going to make sure she gets reasonable accommodations for everything that she needs. And they are going a little farther than they would, I believe. And, based on the situation she's in, I can understand why They don't want everything. Um, they don't want everything like totally tossed out, you know. And I get that. And he has to be very careful, but it has made it more difficult for him. Um, he has changed. I am completely like I am aghast and impressed and like cannot believe how he is able to try to manage this situation, manage the unmanageable Sarah Boone. He is trying to give her as much fairness as possible, but still rein her in with the ridiculousness, and it's not easy. Hey, Beck, good to see you. I'm glad you're here. And yes, 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 Rocket Couch, I'm playing VTuber again today. You know, yes, I'm going to get to that, Rudy. Yes, that's part of it all. That's part of it all. So let's go to those couple. Let's just talk about some of the motions first before I get there. Okay. Mm. All right. I can pull this slide up. This one's in order. Okay. So these are some of the motions and requests, and we could talk just a little bit. This will just give us a little bit to go by here. Uh, that what has happened in the last couple of days. Some of these happened on the 5th, some of these happened on the 9th. I am going to give you all links to those actual hearings, and we're going to discuss some of the actual psychologists that are weighing in on here because I would like to focus on communication on what's going on in this court because I think it's going to be important for you all to get ready and try to understand the two different styles and how they're communicating together and what all of this means before we get to trial on October 7th. Okay. So these were the motions or requests. Now, if it says requests, there was something else that happened after the night that I'll explain when we get down to the bottom. But anyway, a motion handwritten in proper format to the judge in the court to be filed, properly submitted, handed to the judge again on the 5th because he said he didn't get them yet. But anyway, these were addressed. Evidence access was approved. There are multiple orders on file in regards to this, and we're going to go on a little bit about that now. Basically, the judge contacted the prison into access for, remember, Sarah was always complaining that she had no access to her case information because she didn't have a laptop. She didn't have any information. Nobody was giving her anything. The judge, in conversation with the prison, was able to secure her laptop, was able to make arrangements for all of the discovery to be put on USB drives, to make actually these arrangements ahead of time with the prison, that they would have a process to transfer all of this and give her access. Okay. And then when he started those conversations, and also at the same time, the JAC actually submitted some documentation in response to some of these motions, and one of them was about the investigator. And the investigator is from Prison Break Investigations. The owner and chief investigator, Billy Lane, has been at all of the hearings since. He's been requested to be there by the judge because he was already, they had pre-approved JAC. So they just automatically said, fine, we're just like, this guy's hired. Well, we're going to pay this. This is fine. We have no problem with it because they knew who it was, because Patricia Cashman did her job. She did what was required. Okay. Sarah Boone's previous investigator didn't want to work with Sarah Boone anymore. Okay. You can't force them to work with you. Okay. So here we go. She needed a new one, and that was secured. And Patricia Cashman, the previous attorney, she did get all the paperwork to the JAC and got all that taken care of. So that one really didn't get hesitated at all. Like, it's just that Sarah's acting like she doesn't know. Now, has she allowed Patricia Cashman to provide her the information necessary to where her case actually was, what the evidence against her was? But you see, I'm starting to notice a pattern here in these hearings where Sarah's representing herself and able to talk. Sarah doesn't care about any of that. Sarah gets fixated on things until she feels they're resolved to the point satisfactory where she has won. Sarah only wants to win. A point, a statement. You're not allowed to say anything about Sarah. And I'm going to show you this in the next few things that we discuss in these motions. It has been so eye-opening the last 2 weeks. I have watched way too much Sarah Boone. Okay. So the witness deposition calls that she also wanted to get was another JAC filing to get things terminated, but she didn't list any witnesses that she wanted to depose, or she didn't list any costs, and it was all just blank, blank, blank. And so the JAC said, we can't allow that. And the judge says, I can't even put that through. There's nothing we can do, but you can refile it at a later date. There was a little bit back and forth with that. And through all of these, Sarah kept bringing up, I don't have access to my evidence. I don't have this. I don't have that. Even though while they're addressing it in the August 5th hearing, face to face with an actual procedure, she's still bringing it up while they're talking about how she will get the access. Like, the judge has done what he needs to do, and she's still push, push, push. This isn't good enough. This isn't good enough. My rights are being like a parrot. And what she's doing is she's making a little bit of an adversarial relationship with the judge already. If this is how she spoke with her attorneys, no wonder no one wants to work with her. I see it clearly now. Judge Kranick has been very patient, very informative, very corrective of the record lately. And we're going to point out some more of those. Okay. One of them comes up with the fact that she was demanding an evidence. She said that the judge was wrong. The judge was wrong in making her pro se without an evidentiary hearing on competency. And both the JAC and the judge needed to actually educate her on the fact that Sarah Boone didn't know what she was talking about. There is a difference between a right to counsel and standby counsel when someone volunteers to be pro se, when they are requesting the court to make them pro se, their own attorney. Then there's an evidentiary hearing of types to see if that is possible based on how the actual defendant is, what access, competency. Okay, it's up to the court to decide whether they need a competency hearing. Some type of hearing happens. Sarah was demanding one and was schooling the judge in language in both her motion and in court to his face that he didn't do anything properly because she didn't get that, and no one asked her if she wanted to defend herself. Well, Judge Kranick, and I really advise you all to go back and listen to these hearings on Sarah's interaction alone with the judge. You expect it. But to see how the judge has turned around in his dealings with her, he is not disrespectful. As a matter of fact, he is very respectful. He always refers to her as Miss Boone. He addresses something immediately, and he stopped letting her take control of the situation. He has set his boundaries that this is his court. She will not misspeak, lie, manipulate, twist, anything. Like, he's made several very clear statements to her and very clear questioning to her that should actually put her on notice. But she's relentless. This thing with standby counsel was an education on her behalf. But she still complains that it's the judge's order that made her pro se. And she doesn't want to be pro se, and she brings it up every chance she gets. The judge, after re-educating her on what an evidentiary hearing for pro se was, re-educating her that she needs to read the 16-page order that he diligently reviewed all of her correspondence, all of her complaints about her attorneys, all of her difficulties. He read every word. He said he went back and listened to every statement she made. He said he really researched this before writing this 16-page order. And in no uncertain terms, he's basically indicating to her, you need to read it and you need to digest it and understand it, because you forfeited it based on your actions. Your actions. It clearly states in the 16-page order that although her words say she wants to move forward for trial, her actions in not being able to cooperate with anyone involved say otherwise. He really called her on it. And then he said, no, you're not going to get standby counsel. And she tried to readdress it again. And he actually just said denied. And she said, well, is there anything I can refile? And he said, I can't give you legal advice. And she said, I don't agree. And he said, you're entitled to your opinion. She said, well, will it be reconsidered? He said, it's denied. Period. They don't bring it up again. But still, she keeps bringing it up here and there. She makes these digs in all of her other motions. And we're going to get to that. There was in July when we had that, brought her in to tell her that she was pro se now, gave her the instructions, gave her the order, said, that's it. Your lawyer's done. I'm letting Cashman leave. Cashman's giving us the evidence. We'll figure out how to get you the evidence. You're on your own. Basically, that's the short version of everything from that July hearing that we've talked about before. Well, during that July hearing, apparently the minutes of it and the notice of the next hearing date that usually gets posted to the website, it got mailed to the general post office for Sarah instead of the legal post office for Sarah. And she's making a big point of it repeatedly. She made a motion about it. She filed an address correction formally about it. She's brought it up 3 times already. The judge, she annoyed the judge so bad. And he says, he's being very smart. In order for her not to be able to say this repeatedly, he went back and looked at every single one. And only one notice went to that address. And when she came back and complained about it again, he informed her, I've gone through all the records. And only one was sent to the wrong address. And Sarah actually came back. No, I saw filings where there were 3 sent to that address. They may have been, but they were also sent to the correct address at the same time. Like, she's trying to say, no, I went back and looked. And the judge caught her. He's like, because now she's saying, I've seen stuff to the wrong address, but she's also claiming she's not getting any information from anybody, that she doesn't have any of her stuff. Then how did she see it? What is she talking about? He pushed her on it. He said, that's not true. I went through every notice. He called her out in court. That is not a true statement. I went through every notice. And she said, well, what should I do? Like, here's Sarah. She can't just go with what the judge says. What do I do? Do I have to refile the proof to show you? And he's like, I'm not going to give you legal advice. I can't answer that question for you. That would be legal advice. Because it's more important for Sarah to be right about the addresses, to make a point that she's not being treated fairly, that everybody's against her. The whole world is lying. She actually literally accused all the lawyers of perjuring themselves to the judge in regards to their relationships with her. She said it in open court in the hearing. She accused the judge should listen to her because all of the lawyers have perjured themselves in their statements. I kid you not. I kid you not. These little things that just like fly by, during the hearing. And I'm like, no wonder the judge is taking such good notes. He's very well protecting the whole process here, the best that he can. Okay. Now, of course, the address correction, he went out of his way to acknowledge that one error was made and then to inform Sarah that it's not as she is stating in open court. And basically, without putting a warning out, he is warning her with this language that he's using, with these boundaries that he's setting, that we're not going to accept this kind of behavior in open court when we get to trial. Like, does Sarah realize that if she makes this kind of stuff, that she'll be held in contempt of court? That she'll get shut down. She will have penalties for this. You don't go in open court and call all your attorneys liars and expect that the judge is going to be like helping you out. Exactly, Rocket, Liam. It's always everyone else's fault. And we're going to get to that. Okay, the one big win that she got on August 9th is that she did a very well present presented motion in regards to being able to move around and prejudice about her being in handcuffs. How could she defend herself when she can't even take notes because she's in handcuffs? How could the jury's going to have a biased opinion? Blah, blah, blah. She did a good job on that. Okay. And that was all like standard. And the judge is leaning towards her. But prosecution, based on the fact that, like, I think the prosecution was pushing back a little bit because they did talk to court security, and court security was actually against treating Sarah Boone different than anyone else because she did want the leg shackles removed too. And basically the state was like, the leg shackles need to stay on. Other defendants have had their handcuffs and been in regular clothes and all of that, and we agree if she's defending herself, and so the jury isn't prejudiced, like regular clothes are fine. They weren't even really that upset about the handcuffs. Of course, that makes sense. Okay. However, leg shackles, important. They've had trouble. Well, they brought in an officer from the court security who took the stand to testify that it was not in, he did not feel that it was in the best interest of security for the whole court for her to be completely unshackled. And then they talked, and there was questions back and forth. And then Sarah, the judge asked Sarah if she wanted to talk, and she's defending herself. She gets to question a witness also. Here is where there became evident what the trial is going to be like. If you go to August 9th, first of all, a 20-minute hearing lasted 1 hour and 47 minutes. No, not making it up. It's true. 1 hour and 47 minutes, and this is why. Every time Sarah meant to make a question to a witness, she made a statement about how she feels about the whole thing and what her personal opinion is about this, that, and everything else. She was objected to in her format of her questions repeatedly, and the judge sustained it. And then she tried to act like she didn't know what that meant. After the fifth or sixth one, not the first one or the second, 5 or 6 in, she's like, well, what does that mean? And the judge means you're not asking it in a proper format of a question, and we're not going to allow it. And she's like, oh, talk about sour grapes face. Anyway, that didn't go very well for her. First of all, this officer also said he reviewed the prison record, and it seemed like Sarah was not compliant in some things, according to statements on file in her prison record. Now, Sarah took great exception to this, and this is where the questioning came from. Where's that information? Who are these people? Why don't I get to question these people? What, they could be lying. You're not asking me about it. He says, I don't need to, and I don't want to. I'm looking at prison documentation that says you didn't want to attend a hearing. You were asked, you said you wanted to go to every hearing. They tried to get you to go to a hearing. You said you didn't want to, and you wouldn't comply with the officer, and she did it 3 times. Now, this was valuable information to the judge because he had never heard this before. He only hears Sarah's side of it, saying she wants to be at every hearing and her attorneys aren't letting her know and nobody lets her know anything. And then yet in the prison file, they have 3 documented, and some of them all through 2023, by the way. One was in the beginning, and I think the other 2, and correct me if anybody knows precisely, but I believe the other 2 were in 2023. I think one of them was actually January 2024. I'm thinking it is, but I'm not actually that positive. There was a lot to digest. Either way, the judge seemed like you could see him perk up at this information a little bit because this was new. Well, she pushed back hard. She wanted to know details and this, and it didn't really matter. It's the prison record. And the witness was actually like, I don't have to interview you about that. I don't have to interview them about it. I'm going by the prison record. I was asked my opinion. I kind of felt for the guy. He doesn't know what to answer and what not to answer the way that she's going at him. So anyway, she leaves it to where she doesn't get a satisfactory answer. And then she wants to know from the judge if she should actually, write a motion to get all this information. And he tells her, I can't give you legal advice. That is not a question that I can answer for you. And nobody's going to answer it for her. Okay. Well, the JAC was there for the hearing in the beginning. And they did send to Sarah 151-page document. And hold on one second, because that is up on the actual court site. That was one of the things that, like, they actually 151-page document came from JAC with all of the formats to get stuff to them, all of the motion forms so that she just has to fill them out to make it easier for her. A whole lot of information on how to defend herself and get what she needs paid for and acquired, which was, great, beneficial. But, she doesn't seem grateful. She didn't thank, she thanked them that when they said that they were going to send it. But when she actually received all of this, I don't know. Doesn't seem to be very, very grateful about it at all. At all. Okay. One of the mentions that Sarah had was that during this course of actually I should go back to evidence, right? No. Okay. Going back to the freedom of movement. After she goes after this guy, and then they talk to another guy from the prison about it all and how it could be done. The judge does put out an order that says that he's going to grant her ability to move around. Like, he did ask her a lot of questions, like, where do you want to move? You're going to have restricted movement, but we agree. Like, for all the court hearings, her hands will be uncuffed. For the trial, she'll be wearing the stun cuff, which is a device that gets strapped to her leg, and one officer has control of it. And should she get out of control, they will zap her to the point where she falls over. Okay. I did post that in the Discord, and I did see a bunch of people saying, gosh, I just want to see the fallovers. I want to see the zappings. If only we could do the zapping for when she just gets out of line with the verbiage. I mean, I know I talk a lot, but Sarah's word salad is something else. She's not asking questions. She doesn't understand defense attorneys. You defend yourself, you ask questions. You don't make open-ended statements all throughout this whole thing. No one needs to respond. The judge cannot give you legal advice. He's going to try. He is bending over backwards. The patience of this man. I cannot expound enough on how much patience he has had. But at the same time, he's protecting the process. He is setting boundaries. Although he granted her the stun cuff, he's not allowing it in the hearings, although he will allow her hands to be uncuffed so she could take proper notes. It's reasonable. He did arrange for someone to come talk to her in regards to apparel so that she could wear it. Okay. Evidence review was a motion that was put forward verbally, and it actually was in cooperation of the judge, the investigator, Billy Lane from Prison Break Investigation, and the prosecution, because it was all about the prosecution's discovery. They have a USB with 9 pieces of evidence on it that they want to give to Sarah because she's got all these boxes of discovery. It's in the state's best interest not to have the trial delayed anymore. The judge says the date is firm for October 7th. So they have this thing where they wanted to put it all on one USB, what they would present with their witness list, so that Sarah didn't have to dig through those 2 boxes, those 2 USBs, all of that stuff with the investigator, who was granted permission to take the physical boxes to her to have a meeting and go over everything and explain everything to help her open files, because she complained in open court, as Rodin had said in the chat, that she complained to the judge that although the process he put in, she has many, many issues with the process he put into place. She never asked for a laptop. She just sprung that on him in the last meeting, which I believe we all read letters where she was demanding to have a laptop so she could actually research her own case, because the media had everything. She was just going to go to the media for it, right? Demanded a laptop for years, okay? Gets a laptop, throws that in the judge's face, says that she's having difficulty with the USBs. She's not happy with how the prison is actually securing the USBs. They don't take them out of the baggie right. They don't show her the slip that they're documenting, that she's taking it. they're not required to show her their records. Okay. She says she doesn't trust the prison. She doesn't trust the security of the prison. She thinks they're all out. They're all out to get her. Okay. Here they are bending over backwards to work with the judge to give her access from 8 to 4:30 every day to the laptop and the evidence. And she's actually within hours already pitching a stink about it. Okay. After a couple of days, like, yeah. She actually says to the judge, I can't open most of the files. She said, most of the files I cannot open. Well, here's an example of the judge setting boundaries. What do you mean most? How many files you talking about? What are you talking about? And she says, well, there was one file that had like 5 things in it and I couldn't open it. And when I opened it, the other files, like you couldn't open them either. And he says, what files was that? Oh, I don't know. I just moved on to something else and looked at all the evidence. And it's like, so he caught her in a manipulation there where she wanted it out to the public and on the court record that she couldn't open up her files. But it's not true. There's a molecule of truth to it. Maybe one file she couldn't open, but that doesn't mean that it wasn't there in a different venue. Because then the prosecution had something to add about that. They will admit that there are 2 formats to every video that's on there or any audio so that they could make sure she could open it. So if she was opening up one that didn't have the format, that doesn't mean there wasn't one there that did. Okay. And we all know that the standard format PDF for all the legal documents and all that other stuff, or even a Word doc, you know that that's on the laptop. So it must only be an audio or a video file that was the problem. And the state just clarified that they made sure that they were all there in the most common formats possible and in the original format received. Now, granted, based on her laptop, she may not be able to open the original format received, like from her cell phone or from the vest cameras of the police, the recordings that were made, or the investigation room. Maybe those are different extension files or different apps that are needed that she doesn't have access to. But they went through all the trouble of making sure that that same evidence is listed in a format that is readable. But Sarah would rather come and paint a different picture to the court. However, Judge Kranig is going to keep asking those kind of questions because I think he's got a good read on Sarah Boone. And I think he clearly sees her manipulation of the process. Does he want her to have a fair trial? Absolutely. Does he want it to come back to appeal and be overturned? Hell no. He doesn't want to see her again after this. Come on. He wants this trial to go through, and he wants it to go through fairly. This man is doing everything he can to get her what she needs to defend herself and yet not delay the process. It's tricky. Very, very tricky. Okay. After Sarah got access to all of the evidence on the laptop, she proceeds to complain about the timing and this and that. The judge told her that he has no control over any of that. That is the prison. So she did write a letter to the head person full of complaints about the whole process. The judge did agree that if the prison could come up with a way that she could get the hard copy evidence, it was turned over to her investigator. And the investigator on the last meeting was going to meet with her at 9:00 in the morning. Okay. And they were going to start going over stuff because then she wants all this evidence, but now she's telling the judge, well, what do I do with it? Like, I clearly don't understand any of it. Like, I don't know what I'm doing. And it's all your fault because you're making me defend myself. It's all your fault because you didn't give me the choice. And she keeps bringing that up. That the judge did this unfairly, violating her rights to counsel. She didn't do anything wrong. And she didn't do anything wrong. None of this is her fault. Okay. The state has gone so far to put everything on a USB that they want to present to let Sarah clearly know the case against her. And during that hearing, when they were all discussing that, he also kind of slipped that he was willing. like with the judge and in discussion, much to Sarah's chagrin, they're all finding ways to let her see the evidence, to go over and make sure she understands. And she's like sitting over there with this boo boo face on, really agitated that they're helping her. The state put everything on a USB, said they would go to the prison, because here's where something very interesting got slipped in the hearing. They're going to go to the prison to walk her through the evidence so she could ask them questions, and then let it slip that they were probably going to be there anyway because previous attorneys had let them know that Sarah wanted to talk to them in regards to a possible plea. Dun, dun, dun. Listen, at this point, if Sarah wasn't so crazy about letter writing, and believe me, in motions alone, she's getting her fix. I mean, these things are pages and pages long. Well, the language. She must be having the time of her life, which would be the only reason she doesn't exactly take the plea, because of the attention and little desires are getting filled there. She just thinks she's right. And the whole system is wrong. Well, she did get granted to have access to the hard copies, and she is in now control of exactly, like, she has been given the things that she asked for. I wouldn't say she's in control. I misspoke there. I would say the court is still in control, because they did say that is under prison control, how she has access to her physical evidence. And here's the thing. Even though they gave her the laptop and everything is on USBs, and she has access from 8 to 4:30, in her letter, she actually literally complained about all of that too. And that's one of the things I'm going to bring up. This is the letter. Okay. Let's just see if I can make it a little bit bigger for you guys. There we go. All right. This went to Captain D. Giovanni, who is at Orange County Correctional Department, in charge of all of this kind of stuff. And basically, Sarah's objections are that she wants a few things. And the judge actually said she had to deal with the prison about this. It's out of his control. He cannot order the prison to do anything. So she has questions and concerns for a laptop, phone, and etc. Okay. She goes on in her things that she needs, like she needs their help to excel at for her case. She said, with hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe I can achieve more efficiently, effectively, equally, so I am able to plan my very overdue exit in the very near future. Sarah Boone believes she's going to get herself off. Yep. So she's been instructed to contact you directly for the listed questions. She wants her laptop times extended. Right now she has 8 to 4. She wants 7:30 to 10 added because she needs to vigorously work on things. She wants another 2.5 hours. Okay. The USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to miscellaneous officers in the down for the day. All of my information is highly confidential, and I am trying to avoid further leaks on top of the already recorded jail phone calls, visitations, names, and details, my inmate interactions, meals consumed, etc. The things that she's complaining about here being leaked, they're not leaked. Phone calls in the jail are always called. Visitation records are always public files. Okay, details of her inmate interactions make it into her prison record when she acts up. And they do need to make sure this is all documentation. Her actual prison time, you're in prison, boo-boo. Sarah, read the room. Take a look around. There's bars on your door, right? Like, get a grip, girl. You're in prison. None of that was leaked. That's all public files for the prison. None of that was leaked. This is the manipulated language that I'm referring to. These are the techniques that she's trying to get by the judge and everybody else involved. And everybody's starting to get a clue. Captain Giovanni is going to try to help, but I don't know if her calling out the whole prison system as being untrustworthy is really going to get her anything. She returned her laptop and USB together, and she received back the laptop, which is not charged, and the USB driver separated with the protocol security paperwork removed that she needed. She doesn't need the security paperwork. They do, as to when she takes it in and out, because Sarah said she didn't think they were going to give her access to it. And the judge wanted to see that there was a process that she was getting access. And this is noted by this letter that made it to the court document. Not only was it sent to Captain DiGiovanni, it's part of the court record. And the judge must have read it because he issued an order today. It says that as of the 12th of August, the prison will send him a weekly report of how she's getting her stuff. All the sign in and signed out, because he doesn't want this kind of conversation in the record when it's not the truth. Okay, this is the kind of stuff he's trying to prevent for her saying that her rights were violated or she didn't get a fair trial. He's dotting the I's and crossing the T's against anything that he does being overturned, or that her having the rights to an appeal because she didn't have access to anything. They are bending over backwards to provide it to her, and she's still complaining. She's not a free person. She doesn't get to look at it in the middle of the night. Who is in control of my laptop and my two SPUs when I return at the end of the day? Where do they go? How are they secured? Why are contents being removed and opened? No, they're not. They have to take them out of the baggie, Sarah, to put them to you. Allow me to keep my USBs with me. This is the same woman who said, I have no privacy at the jail. I need a lawyer because I have no privacy to look at my own documentation. I can't keep anything in my room because it's not safe. Everybody's butting into my business about my evidence and stuff. There's no place to put it. But now that she wants it, now that she wants to be in control of it, it's all, I can keep it in my cell. Oh, give me my boxes. Give me my USB. Give me this. Give me this. Because all those other letters I wrote to you and turned you blue and inside out, complaining about not having any privacy and not being able to do, not having a good situation to do it in. Oh, that's all moot now. I've changed my mind. Forget all that. Forget all that. Forget that I told you over and over again what was wrong with my attorneys. You never even asked me. Well, you wrote how many letters? 9, 10 letters? The last one was 58 pages. I think we all know what your issues were, Sarah. And the judge read them all. Sarah seems to forget. She wants access to a private classroom that's not being used most of the time. So here it is. She wants the privacy of everything in her cell. She says there's no place to view anything. She wouldn't let her attorneys show her the evidence or go. She complained to the judge that they wanted to show her during their meetings because they were allowed in this classroom or they were allowed in a meeting room because she didn't want anybody else to see. She used that as the excuse as to why she wasn't getting the information from her attorneys. When her attorneys proved that they were there to give her information, Patricia Cashman, I am speaking of here, proved that she went to the jail and Sarah walked out of the meetings. She tried to say that it was because of the snotty attitude and because she don't want anybody else seeing anything. And it wasn't a place that could be, they weren't taking her privacy needs into consideration. Okay, but now she wants to do it in an open classroom. That would be a nightmare for the prison. She wouldn't leave if they went to use it. She knows she'd be insisting on being there, whether it was convenient for them or not. You've got to now have extra guards to watch her. She really wants special privileges. I don't know where this one's going to go with the prison. They are not obligated to do any of this. She does want earphones and headphones so she can listen to her discovery in privacy. And that's not unreasonable. I can see them doing this if they can get access for it. I don't see them paying for it. I can see that they will allow it and they will tell her they'll allow it. And then she's going to have to petition to JAC to pay for it for her and get them in. And that's, again, going to be a delay. And I can guarantee she will be screaming at the top of her lungs about that for I don't know how many days or weeks until they come in about how her rights are being violated. Okay. Oh, but now she wants internet access too. Why does she need internet access when she said she doesn't want to use a USB for all her stuff? She wants hard copies of everything to do her defense. Now, she wants internet access and restrictions. She needs to research heavily her defense, all of it, locate witnesses, any experts, the clerk's website. She has an investigator that's being paid. They can locate witnesses. Okay. Correspond with the judge. Judge already told her, you can't correspond with me directly. Here's the email for my clerk. We put things on file. You file most. You cannot correspond with me directly. She wanted a way to talk to the judge. She said, I can't talk to you when I want. And he said, you can't correspond with me that way. No, that's not permitted. She literally thought he was going to, turn over a phone number? Seriously. Everything I need to educate myself. Everything I need to educate myself on about being pro se, etc. Word program to type any motions, make notes, list. She wants a word program on the laptop. Anything I need to document and record for future reference of sharing with potential near mates. I need to be able to open and create a document, save work product, etc. Except for that, she's saying she can't access any of this stuff anyway. Permit access to a word program to use fully, properly, and progressively. And now she wants telephone access. As you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make any and all necessary calls for my case to use in my trial. I have no other means to contact anyone that is not collect, which incredibly diminishes most, if not all, of my opportunities to properly prepare. That's false. You do have other ways to communicate. You've been doing it all along. You handwrit, I don't know how many of those motions. Nobody's going to get you a word program to make your life easier at this point. That is unreasonable. And as far as access to a phone, why would you be granted access to a phone to harass who? Why? That is, no. If you didn't appreciate Patricia Cashman taking your collect calls, which she did, why is the judge going to allow you to abuse anybody else in such a manner? And why would the prison allow you special prisoner privileges because you are pro se? Maybe you should have thought about all of this when you actually had attorneys that could do all of this for you. She is actually working with them on the discovery hard copies. It came up in the hearing. The judge actually asked her straight out, have you told anybody at the prison that you have everything that you need? Because apparently that is documented somewhere. And she said no, but that a Miss Hall came. He said because he spoke with Tiffany Hall and he understood that Sarah and her had talked and that Sarah was making arrangements to get rid of some other private property that she has in a locker so that she could store the hard copies and they could make arrangements. But when he said, did you speak with Tiffany Hall? She said no. He said, well, who did you speak to? She said, a Miss Hall. And he just stopped dead. And I'm like, okay, Sarah doesn't listen. Sarah listens only to hear what she wants to hear. Sarah here listens to hear only specific answers that she wants. And she just keeps going until she gets it. She clearly was saying she didn't speak to Miss Hall. She obviously did speak to Miss Hall. She's not listening to the judge. She's not really focused on what's happening in the hearing. Only the little parts that she seems to be are the most relevant. Like until she can get her hands on a piece of paper in that evidence box, you know, where more importantly, if you're working on your case, doesn't it like mean more that the state is actually coming out to explain the evidence to you? And then the judge did set a deadline on that of September 3rd, I believe, or 3rd or the 9th. I'll have to look at the dates, but they are, if they don't get to meet up with her at the prison, they will actually have this hearing in the court. They have it scheduled, and the state will go over everything, and she can ask the questions, and they can do everything. And that is when the media came up. Sarah was complaining that the media has access to everything, and the judge does agree that that kind of a hearing should be closed. And he's going to look at whether he can close it or not, because it is extraordinary that they're actually doing it in the public courtroom with the prisoner, but it's basically for access. And as the judge clearly stated, also because if it's not documented prior and sufficiently that you've had this meeting with the defendant, and he was talking to the state at the time, he told them, then if that's not back to me by this date with proper documentation of everything that you went over with her and, you know, agree, we are going to have this, because this needs to be, I want to see this happen. He doesn't want any more delays for his trial. So he wants to make sure that before that status hearing in late September, that all of this has been checked out, okay? And that she did get knowledge of and has to admit publicly in court that she saw certain things. Because what Sarah's been doing is being given the special privileges, been given access, and then denying anything is actually happening and still complaining as if it never did. August 5th, they said that they would start the process. Everything was turned over to the investigator. Like everything was turned in. Everything was turned in on USBs. They were given to the judge. It was going to be forwarded to the prison. She was going to get her discovery. And she still spent, like, I don't know how long complaining that she didn't have her discovery, even though they were working on it right then and there. And she knew the process had to be set up by the prison afterwards, and that it was well in the motion. And she filed all of these motions on the 5th, knowing that the hearing on the 5th was about her getting her evidence and the process, and that he would have an answer for her. And he did. And she totally ignores it. I don't know, totally. It's just like, it's just so frustrating. She wants to keep all of her hard copy evidence by her bunk for readily available viewing and unrestricted access. She goes on. And I'm sorry, like, about the watermark, but that became necessary because some people just are not cool about stuff. Okay. She spoke to Sergeant Casey in the courtroom, requesting your time, please, at your earliest opportunity, to convey the importance of my request to hopefully be completed. And she did send it to Judge Kranick. It is posted. I pulled this right from the actual site. For those of you that want to read the whole thing, there you go. That's a shareable link. Before I go back to the other presentation, I want to add the results that were documented by the court for Sarah. It gets mailed to her. It's put on the website. I do believe that everything needs to be mailed to her. It would be more convenient if they allowed it to be emailed and the prison just gave it to her, like they printed it out and gave her the printed email. But I don't know why they're not doing that. I know some places do that, but it's just a matter of policy. The prison itself is in control of how communications get to the prisoners. Okay. And, you know, they can only do what they can do. All right. So on this one, as of this cause came before the court on August 9th on motion for defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Hand filed on August 5th, it was handed to her, The court, having received the motion, having reviewed the court file, having considered the testimony, like we said, it happened on the 9th, and evidence offered, the arguments offered by counsel for state, and having considered the arguments offered by the defendants, I hereby, they granted that motion. And it'll be a stun cough, like for the court, and her handcuffs will be off for all her future hearings. Okay. The procedures for hearings and for trial are placed on the record and shall be complied with by the defendant. Prison break investigations by and through investigator Billy Lane shall take the discovery that was provided to the court on June 28th and shall provide same to Major Malik X Muhammad at the Orange County Jail today, August 9th, 2024. In other words, everything's being transferred over to the prison to manage at this point. Prison break investigations by and through investigator Billy Lane shall take possession and custody of the USG jump drive, which contains the state's digital evidence tendered in open court on August 9th, as the state said they would, and shall provide same also to Major Malik Muhammad at the Orange County Jail today. And they're going to add it to the laptop. Okay. Prison break investigations by and through investigator Billy Lane shall provide the digital transcripts by deposition of detectives Chelsea Kopsel and Scott Lowen. Those are the arresting officers and investigators in her case. In a USB jump drive, the depositions, and shall provide same to a representative of the Orange County Jail on the next morning that he said he was going to meet with Sarah, August 10th at 9 a.m. Now, it is on file that Patricia Cashman sent those depositions to the court because they had with the investigator, they were part of the evidence, so that they were on file so that Sarah would have access to them. None of that was delayed. That was an actual deposition. They were in process of getting transcribed and everything when she actually left. And so they weren't part of the original discovery boxes that were turned over. But having been received, they have been officially documented on the court record, received in court, and sent. Actually, they were given, hard copies of it were actually given to Sarah, I believe, at the hearing. I do believe that they said that. Okay. They shall file with the court a notice reflecting that the discovery and the USD, this is prison break investigations, shall file with the court a notice reflecting that the discovery and the USB jump drive, which contains the state's digital evidence, was provided to, Major Muhammad at the Ocean County Jail, and the date and time and everything. Basically, Judge Kranek has put a procedure in place that says that everything that everybody does is going to be documented from now on. I want time, date, place, what you gave her, when you gave it to her, and that she got it. Okay, he wants everybody documenting everything. Okay, and now, as I said, he did put in an order that said he wanted actually the prison to send him a report. Yep. On August 14th at 1:30, a hearing will be held in courtroom 12A, Orange County, regarding defendant's review of the USB jump drive, which contains the state's digital evidence, and defendant's August 7th letter provided to the court on August 9th, and the media's participation in the physical evidence viewing of September 3rd. That's the date, September 3rd, not the 9th. The pertinent case law is attached, okay? The judge is reviewing everything, okay? So, and basically that's going to be a motions hearing, okay, about the stuff that she handed over to everybody and the letter that she sent in, and what can be done and what can't be done, and just dot the I's and cross the T's on the motions that are left undecided yet. And that was whether the media could be there, and then her letter to Captain D. Giovanni, that really the judge has no control over any of that. Okay. In accordance with paragraph 7 of the court's scheduling order and notice of hearings entered on August 5th, no later than August 23rd, defendant shall provide to the court a written exhibition list identifying any and all digital exhibits that the defendant may be bringing to court. Okay. Make to seek to use at trial. This deadline may be extended upon showing of good cause. She also needs to, by the August 23rd, do any objections to the state's digital exhibits. Okay. No later than August 23rd. Okay. So they're putting her on a time test. I mean, she's demanding what the state has, but she hasn't prepared anything. And granted, she just got her information, so that doesn't really seem that unusual. But for you all that really like to handle these things, because I showed it, of course, I'll give it to you. And I have a few other things for you too. Let me just go back here. Okay, so that's where we were. But I'm going to talk some more about the communication. Okay. The next thing I'm going to do is give you guys the links. Unfortunately, the actual hearing links, are not that great. Okay. Here they are. The one from the ninth has really low audio on the part of Sarah and the witnesses, but the judge is really clear. And so that one came from Court TV. But Law and Crime actually had a better one of August 5th that was really clear and concise. And the reason I'm giving you these links, if you haven't seen them before, is that even if you just spot check them a little bit to hear how the communication is going between the judge and Sarah and how she was presenting herself in her hearings currently, you're going to get a good idea of what it's going to be like at trial. Okay. These are some of the notices, things that I noticed. Okay. Sarah is using gaslighting language consistently and a lot. Redundancy. There are issues that have been addressed in court, like whether she's pro se, whether she can have this, that, or the other thing that the judge has repeatedly already addressed that she keeps bringing up because she doesn't like the answer. She doesn't seem to realize that she's not the one in control. The judge is. She's not even being really respectful about it. She has made accusations of the judge violating her rights, of attorneys perjuring themselves, of the prison not being trustworthy with her evidence. Okay. She is making statements of opinion and wanting to put her case out rather than ask questions when speaking to people that are sworn in on the witness stand, or even talking to her investigator, which she's got open time to talk to him in court, ask him a question, but she doesn't. Like, or the state's attorney, when the judge asks her, do you have any questions or anything to add, she just wants to make statements about, this isn't fair, I'm pro se, I don't want to be, I have not had my discovery for 4 years. She literally believes that those boxes that were just given to her, she should have had them from day one, because apparently the attorneys shouldn't. Like, not that she could do anything. There was no vehicle to do that. Nobody gets that. But in Sarah's world, it seems like just because nobody else gets it, it doesn't apply to her. She seems to have a whole different set of rules. Okay. She consistently is saying that she's not being heard. She is being heard. Every word she says is now being analyzed and pushed back on, because she's using things like most or all or every, and it's not true. Okay. She is getting her notices. They have to be mailed because she's in jail. There's nothing anybody can do about that. They're not going to put the expense of a private courier to deliver her every single piece of paper that hits that court file. Okay. If they do grant her limited internet access, that might help, but it's still not a certificate of service. She went on for 20 minutes in one of the hearings about certificates of service, which the judge says, no, I'm not going to send a separate one for every little thing. Everything is documented on the file. And I handed you the court notes. And you were here when I went over the process. And I talked to you about the process and asked you questions. Like, no, I'm not going to, do all that. She claims she's not being heard, but all she wants is her opinion known. And more than that, it seems like not only known, but agreed with. Or she doesn't stop. The judge has really changed his communication style a lot. He's been calm, informative. He's polite yet firm. He's setting boundaries. He's correcting the record, like he did with the pro se argument, like about her wanting a standby counsel and insisting that he is actually breaking the law by not allowing her an evidentiary hearing on pro se. He corrected her. He had everybody correct her until she said she understood. Push back on accusations without context, like I can't open up the files. What do you mean? Well, most of the files. What do you mean most? He says. And she has to clarify. And when she has to clarify, she gets stuck with having to tell the truth, the exact truth. Date, time. What are you talking about? What's the label of the file you can't open? Because he is going to resolve the issue. If there is a file you can't open, he's going to send somebody to look, and he's going to find out that she opened the one that she could right next to it, and he's going to call her out about that, and he's going to clarify it for the record. And he's not going to do it embarrassingly either, although she should be embarrassed. And she should start to take notes about this communication that's going on between the two of them, because it can only help her case and her defense if she would just read the room. Bullshit isn't going to fly. You can't take things out of context. You can't obscure the real issue and get any results. Not in a court of law. She's really going to have some difficulty. She really is. When I talk about one of the things that I noticed, it came up in another video that I watched. I watch someone by the name of Guilty Words who psychoanalyzes everything that gets said in these hearings. And they did one on Sarah Boone and on this particular hearing. And I am going to refer to a few things that they said in there. And so I would like you to give them a view. I did watch it. I found it very informative because especially when it came to this communication, everything that I was thinking, like they actually reaffirmed, like, yup, that's what I see too. And I'm an expert. I don't claim to be an expert. This is just stuff that just stuck out to me. And so to hear it coming from another source, actually several sources, because I also listened to Dr. Barry, who did the other hearing. Now, both of these are on different hearings, but you'll find that they are concurrent in regards to the use of language, what Sarah is actually doing in the courtroom instead of focusing on her case, just kind of narcissistically more on her being right and her proving that she's the smartest person in the room, which is really starting to get very annoying because she's really going to just delay her trial, but it's not going to get delayed. The judge has repeatedly said to her, the dates are the dates. But in the communication with the judge in the last two hearings, the things that were pointed out in the Guilty Words video also was that the judge was using stats and informative and corrective. And this was really sticking out to me. 22 times Judge Kranick referred to previous information that Sarah was already given by him face-to-face verbally, or that she had already acknowledged she had. Okay. 15 times during the hearing that Guilty Words was looking at, and I believe they did the 9th. The number of times that the Judge Kranick actually returned Sarah to the task at hand. In other words, circumventing her long opinion statements about everything and saying things like, that's not what we are asking you. This is what we're asking you. This is what we're dealing with now. I cannot give you legal advice. Well, we're not talking about that. And 11 times where the number was the number that Judge Kranick had to do a full stop statement. And a full stop statement is something like when talking about, are you going to get another attorney? It's denied, period. No such evidentiary hearing is required in regards to why she doesn't get to have a standby attorney. I'm not going to revisit my prior decision. That was already identified by the state. In other words, You've already been given the information. That's already been thing. I'm trying to set my deadlines now, ma'am. Well, we are setting them today. I cannot see a to be determined deadline at this point. In other words, you can't ask for to be determined. I'm setting deadlines based on a trial for October 7th that I have no intention of moving. He has said it clearly. The dates are what the dates are. Because she's like, but I've been in jail for 5 years and I just got my box of discovery. And it's like, whose fault is that, Sarah? He does not have to consider that. Your attorney said the case was the case. Everything's lined up. You just have to read what she has there to do what you're going to do. If you want to change the whole thing, that's up to you. But you got the time you're going to get. And that's it. Your attorney was ready to go to trial within weeks and said it would only take a couple of days. One thing Judge Kranick did recently in the hearing, after dealing with Sarah for the first hearing and listening to the way she was presenting herself, he extended that trial. We're not a week anymore. It looks like we're going into 3. Yeah. He could read the room. I have nothing but admiration right now for Judge Kranick, and I actually feel really bad for him and what he has to put up with. Another thing he said was, I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. In other words, Sarah accused him of drawing conclusions from what other people said about what she needed in regards to her evidence and what she needed in regards to an attorney. And he said, no, I read all of your writings and I've heard everything you said. And when she keeps at it, he says, ma'am, I'm not going to revisit that. And when she asks, well, I need to get in touch with you. I need to be able to communicate with the court directly. He said, you cannot correspond with me directly. I cannot give you legal advice, he said over and over again. You cannot correspond with me directly. In other words, when you were the defendant and had an attorney, if you had a problem, I might be able to advocate for you. But I can't do anything like that now. The system is the system, and you're going to have to learn to work in it. And she's really having some difficulty. Definitely having some difficulty with it. In guilty words, Judge Kranick went over and over about her, it's the defendant's motion reported immediately for promoting effective standby counsel, and he just goes over it. It's denied. You need to go back to the original. There is no constitutional right to stand by counsel, which she went into this long thing about them via the court violating the rules, and she didn't know, and they all had to re-educate her on it. Denied, period. He closed the door, stopped bringing it up, but she doesn't stop. She's playing ping pong ball about the discovery. In the hearing where she was getting the discovery, she still was going on and on and on about not having it, not even listening to the process that the judge was laying out, not even listening to the fact that he had already contacted the prison and arrangements were made, and that that's what this hearing was for. She didn't. So she, in the hearing where the boxes were right there in front of her, she says, well, on July 27th, for all my pretrial motions, I have yet to receive my discovery. And I didn't read it. So who am I supposed to ask? And again, I have to receive my discovery. So I don't even know what it is that I need. On and on. The second ping pong ball that she keeps going over, and this was Guilty Words who actually put this. She calls them ping pong balls. The ones that Sarah refuses to let go. Again, it's pro se. And she goes on this long tirade. And I do recommend that you watch the video because it's great. But here are the things that Sarah won't stop. And what keeps bringing up every time she's in a courtroom. She objects to being pro se. She had no control over it, and she doesn't want it. And this is a violation of her rights. Evidence access. No matter what you do for me, it's not going to be enough because I'm going to come up with something else, okay? Because I swear, I had a nightmare last night. that she wrote a 15-page motion about that she didn't like the cheap pens that they gave her to write with because they get ink on her hands and they distract her. And it's all a setup so that she can't do a good job. And they want her to look bad. I kid you not. That was a nightmare. I mean, I'm getting a little too obsessed with this case. I get it. Like, the break was not long enough. She insists everyone lied. The lawyers perjured themselves on file. The state's not being honest about the evidence. She doesn't know where that evidence came from. How dare they? Most of it's from your own phone, boo-boo, but that's going to be interesting. I can't wait. I wish we could see the evidentiary hearing just to see her reaction to the evidence, but I know we're not going to be able to. It really would be a violation of the procedure because it would not be fair to leak it to the press and to the media, all the evidence the state has on her. We do know some of it already that was put out there. We don't need to know the case. We can wait for the trial because we don't want another loophole to exist for Sarah to manipulate and wiggle out of this. The last thing we want is a mistrial. The last thing we want is her rights to be violated so she gets off on this because there is a victim here. Okay? There is a victim here. And he needs his justice. His family needs his justice. Okay? George needs his justice. Okay? And Sarah just thinks that it's all about her. And it's not. And Judge Kranick has got good control of this right now. And he realizes this. She's talking about clerical errors. One clerical error of an address on one notification that happened on July 27th, which was corrected the very next day and resubmitted. Not asking me what I think about it, my opinion. You didn't come to me. He's the judge. He doesn't need to. Your motion is your statement. The questions he asks you, the answers you give, are the information you give. Every letter that you put on file is what he has in every statement you made in open court during your hearings when asked. That's all he has to look at. You don't get to rewrite history with the judge. He has all the information he needs about you. And he doesn't need your permission to do his job. Again, she says over and over again, it's unfair. This whole process is unfair to me. I never asked you for a laptop. Why is all my evidence on a laptop? That just blew me away. Even the judge said, I do believe I read that in several of your letters in that you did request that. I believe that when we have our next hearing, he's going to re-educate her on all her statements and requests. And again, always, always, always saying that her rights are violated repeatedly. Every chance she gets, she just won't stop. So that brings us at an hour, almost an hour and a half, and I'm going to give you the status of where we're at. Obviously, we're going to have another motion hearing tomorrow. And I don't know if we are actually going to be in on that one or not. Like, I think we are. On August 22nd is the deadline for the defense evidence and for her to do her witness list. She has received all of the state's evidence. September 3rd was the actual deadline for the state evidence review, but I do believe some of that might happen on the 14th. I'm not sure whether the cameras will be there. If not, there's going to be another one on September 3rd, and I doubt the cameras will be there. The status conference was scheduled for September 24th, the pretrial status conference, to make sure everybody's ducks are in a row. And that was rescheduled to the 26th. Gave her 2 extra days based on some deadlines. However, October 7th, the trial start date is solid, but the time allowed for the trial has been extended. In one reporting said 1 week, and another said 2 weeks. I thought I heard the judge say 2 weeks. And I'm going to just double check that. But all right, here we go. I am now going to check some comments here because you guys have been very patient. I don't mean to not address any questions, but it's hard when I'm doing it. Mousy says, quite a while ago, sorry, she is making it hard for herself. I agree. Someone somewhere is a Lifetime movie script in the making. Exactly. Exactly. Somebody better check her luggage. Oh my goodness. She wants to vigorously work on getting off. Exactly, Liam. And she thinks that she is. Like, she's been there long enough. How dare they weaponize the courts? Oops, wrong case. But she must have control or nothing works, right? Apparently, that is the way it goes, Liam. Because I see the court actually uh, doing everything that they can to get her what she needs and being very fair. Don't kill people. Yeah, don't kill people, then you can have privacy. Like, don't go to prison. And then you can shut and lock your doors. Exactly. She'd have more privacy before the USB. Then at least she might have been able to make a box for it. Yes, it's true. I don't know what she plans on doing it. Uh, so she can corrupt the evidence? Maybe. She did get caught in a lie with Patricia Cashman, and she didn't appreciate it, about demanding some medical records that Cashman proved she already had to the court because Sarah's writing was all over them. She had them already. She just likes to pick these little things and try to act like everybody's an idiot. Her defense team, is she talking about the Dolphins? Apparently, because she doesn't have one. She does have a private investigator who, being paid, he's the owner of Prison Break Investigations, and he is being very compliant. He's going to the prison to talk with her. He's going to go over as much of the evidence as he can to help her try to understand some of it. And he is ordered by the court to do this, and he's been doing it. He's been showing up for every hearing as instructed, and cooperating with what the prison and the judge have tried to put in place to help her. In order, also, he actually willingly said that he would take the boxes back if the prison couldn't accept them, and bring them to her, when necessary. But then she decided that wasn't good enough, and she wants them there all the time. But she doesn't want the prison in control of securing them. She wants to be responsible for it. Why? So when she goes to dinner, she can say that somebody broke into her room and damaged it. Like, that would actually be a great risk for a mistrial and appeal. And I really don't see it happening. Sarah Boone could be the new definition of frustration in the Oxford district. I believe her picture's there, actually. And hello, Mark. Hi. Thank you for joining. I'm sorry I didn't greet you when you showed up. I was busy up here talking and stuff. You know. And Couch, you're right. I'll bet you that she is actually in the process of rewriting that dictionary to her own standards as we speak. You know, I'm guessing her next complaint will be that she's unable to access her evidence due to a payback. I don't even know what that is. A PEPCAC error? Okay, whatever. All of the words which are used to indict her. Exactly. Exactly. Oh my gosh. Every time I open a document, someone moves my hand to click the X button in the corner. Exactly. Mom, they're staring at me. I still have to see that. Not looking forward to long, Sarah. I don't know. What? I don't know. Not even your love letters to her? I don't know. I'd like to read those. Okay. It's Sarah World. You're right, Liam. Where everyone else is an incompetent robot, which should be her servant. Seriously. If she still had a lawyer, I swear she would try and pay them an exposure. Exactly. She would. And I think she's really, like, I think she's a little devastated that her ad didn't work. Like, she can't understand why someone isn't stepping up. Some big organization doesn't see how wrongly she's been treated and is not taking her case pro bono just because it's the right thing to do. I don't know. That might have to do with 8 lawyers that couldn't deal with you. 8 lawyers that went to law school, that deal with the public and the court system on a regular basis, and they can't deal with you. I don't know. it doesn't really look like they're the problem. I'm sure that they had other things to do. Yeah, it must have been something else, right? The weather, um, their dog got sick, um, I don't know, their shoes were too tight. It's definitely not you, Sarah, right? I can't even say that with a straight face. I cannot. Oh my God. Unrelatable note. I just saw a Ryan George video where he described Elon Musk perfectly. I feel like he's playing Monopoly, complaining about the rules, hoarding all the money, and somehow still losing. Oh, that is perfect. That was crazy this weekend. Thanks for sharing that, Couch. So here's Liam's prediction. She turns up on October 7th and complains about not being given notice of needing to be in court. Even though every single hearing he reinstates that the trial is on October 7th, the dates are the dates. They're in writing, they're in stone, they're not moving. But yup, she'll be like, I didn't get 24 hours notice to be here. Just exactly. Yeah. Even though they've made arrangements for somebody to come by to make sure she has clothing to wear, other people keeping records is so inconvenient. Oh my God. It's a conspiracy. Yeah, the nightmare. Yes, Couch. I swear, I woke up going, oh my God, this woman has taken over my life. Yep, exactly. That would be so, I would, she would have a valid complaint there, Liam, if they only gave her blue pens, but they only accept the written motions in black. That could be an issue. I don't think they're holding her to that task. Yeah, exactly. She actually, yeah, life is so unfair, Mousy, isn't it? Hey, dog. So good to see you. I hope you've been okay. Nice to see you around here. She is definitely effective at delaying her trials. Well, she was for quite some time. But I have to give Judge Cranick credit. He took over in January. It was around January, right? Because Wooten got that promotion over to where he wanted to be. And so, he read every letter. He was well educated on the situation when he went through. He was diligent. And I just think he gave her a little grace in the beginning, but she certainly did actually turn it the other way quite quickly. And he has changed his style over the last two hearings, and that kind of stuck out to me a lot, which is why I spent a lot of time talking about it, because I really think it's worth a view, especially guilty words and Dr. Berry, like the things that they were pointing out. I do want you to go to the LawTube channels though and look at the legal issues. I think we pointed them out. I think Judge Cranick is definitely dealing with the legal issues here as best as he can. Most of them are, quite impressed that she's able to handwrite these motions, but it is also frustrating that she doesn't concentrate on the issues she really should, like the quality of the evidence, buckling down and actually reviewing it instead of nitpicking during these hearings. She may be just pushing them a little too far, especially the prison. You can't say that everybody in the prison is against you and then beg them for help and making special arrangements for you. Nothing's going to be good enough. And can you explain why you think they would put themselves in that position? For you to be ungrateful, throw them under the bus, lie about them, accuse them of things. Like, come on. I think the judge did the right thing by putting that documentation process in order. I'm sure she's not going to be too happy about that. We'll hear some little snide remarks. That's the thing. She just keeps making these remarks. Honestly, I think her whole goal with internet access is that she wants to not be in jail while being in jail. Sounds like she's got it in her mind that she can delay as long as she wants. True. So she's trying to edge home comforts back into her situation. Could be. Or she's looking to what other lawyers are saying online that are her options, or with the phone, trying to contact people to come to her aid. She's desperate. She's very desperate right now. I don't see her getting a phone though. I would be very surprised if that happens. I really will. Mousy, she does. She just makes it so hard. She's hoping for a Samsonite advertisement deal. I don't think she's the face to sell it, though. Who would buy it knowing that what happened? No. Problem exists between chair and keyboard. Perfect. Thank you very much, couch. I get it now. Pet cat. Okay. Yep. Mm-hmm. Between the chair and the keyboard. You mean like where the operator exists? Like operator error? Like OE? It's definitely an OE, you know. I found out there is a reason certain documents are filled out in blue ink. It's to be able to tell that they are original and not a copy. Copies used to be only in black and white, and this is true. This is true. But now they can make colored copies, and so it's hard. Yeah. I think she does want any kind of deal in a brand deal. So that brings me to this. Let's spend a couple of minutes. It's been an hour and a half. I'm not going to go the full 2 hours, but let me ask you this: how do you guys think about the state attorney letting it slip like he was going to go to the jail anyway because there had been a request that she may want to make a plea deal with previous attorneys? You know, hmm. I have said for quite a while now that that would be her best option to reduce her sentence. She's already served quite a lot of time. If she cooperated and actually took a little bit of accountability, maybe murder would go down to manslaughter, you know? Maybe they could negotiate. Everybody could win here. Family would get justice. She'd still have to serve her time. Of course, they want the most penalty that they can get. Hmm, I don't know. I mean, we did see that, you know, Chelsea Copel, she came off the Brady list. Her testimony is going to be in court, okay, in regards to how she acted, her misstatements during the investigation and what she did. There's a lot we already know about. I can't wait for the trial to see what the state puts forward. But it seems like they don't have a lot that they want to put forward. I don't know how she possibly can get the videos not to be admitted when she gave them her phone. They wasn't even subpoenaed. She handed them her phone to check. Um, Remember one of her letters when she said that, these utterances that you make when you're under stress should be taken into consideration, that nothing that she said in her interview should be held against her because she was under duress in actually she was just unable to control the narrative. Hmm. Yep. She should have cooperated 4 years ago, and I think that might be one of the problems with all of her use with the attorneys is as soon as they bring up a plea deal, she wants nothing to do with them. She's adamant she didn't do anything wrong. She doesn't understand that you could still be guilty if you did not kill someone, if your actions didn't prevent it, you didn't do anything, and you were able to do something. There's no denying she sat on that couch, that she could have unzipped him at any time. There's no denying she heard what he said when he said he couldn't breathe. There's no denying that. She taped it herself. Accountability has to be held. Manslaughter exists, like at a minimal, but she's unwilling to make a deal. And I think that's part of the problem with all of the attorneys that it has been. Yeah. Maybe she thinks that plea deal means that the prosecution plea for her forgiveness for wasting her time. Yeah, you know what, Liam? That's my next nightmare, right? Sarah writes her own plea deal and puts it through like a motion to the judge instead of to the prosecution, or demands something from the prosecution, JAC, and the judge, like in regards to her plea deal. Like, I'll forgive you if you do all of this, like, because you've wronged me in some way. Wait, she sat on a what? She sat on the couch, not you couch, her couch, and listened to what he said. Like there's a video of it. Yeah. She sat not on the couch, a couch, her couch at her house. Like I would not associate you with Sarah Boone in any way. Never, 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 never. Yes, poor couch. Poor couch. Yeah. Well, anyway, any questions? I think I tried to bring you up to date the best that I could with going over some of some of this stuff. Um like I said, those videos that I went the one thing that I told you was still pending that we may hear about. The media access about the evidentiary hearing, that's still open. And media access to the trial itself, because Sarah has been complaining about the media. In both of her hearings, she looked over to them and she actually said to the judge, how do they know about it if I didn't get a notice? And they were like, you were served your notice. And I did tell you when you were here on the 5th that you would be back on the 9th. Like he told her the date that she would be back. Like it's ridiculous. Okay. Access to the special area. These are all requests to the prison. Requests that the prison allow her to keep the boxes. Complaint about complete prison security evidence. That is all in a letter. The letter that I linked you that went to Captain DiGiovanni at the prison. Okay. And the only motions that I know that are still open with the judge is media access that he said he was researching. And he pretty much is leaning that the evidentiary hearing with the state that should be closed. But he does believe in the transparency that the state has there is regard to the trial. He's not really, he did not seem to be giving that as much weight, you know, because, this is actually a picture of her from the last hearing. Okay, Boo Boo Boone is smirking at the media, looking right at the media guy. She claims she doesn't want the attention to her case, and she doesn't want the media there anymore. But it is my humble opinion, and I'm going to stand on it, that 4 years of actions and letters state otherwise. Those letters that she put out, that was her making her statements and her opinions and her side of the story public for everybody. Because from the very first letter, she knew that it was going to be on that website and it would be public access to all the media and everybody out here that wanted to get it. And she knows that. And she complained about it back and forth, but she still wrote those letters. She still wrote those letters every single time. And she made fun and said she had fans, and she addressed us in those letters. She addressed the media in those letters. For her to sit there and deny that she wants absolutely no publicity and now it's prejudicial after 4 years coveting it and trying to use it to her benefit, it just seems that she's changing her story because she sees there's no benefit to her now because nobody stepped up to the plate. All those fans that she had to give her money to hire an attorney or do whatever, it hasn't come forward. And even if it does, Judge Kranik has clearly made another statement to her in writing in the orders and to her face that even if she acquires a new attorney before the status hearing, he's not changing the trial date. It is what it is. He says repeatedly, the dates are the date. You know what? She can't make money if she gets convicted, Fishner. So only if they did it beforehand. And they wouldn't get access to her. The prison controls all access to her. When one thing that happened in the very first hearing was that for Billy Lane to actually, from Prison Break investigators, to meet with her, she had not even put her investigators on her list for visitation formally with the prison. So they weren't allowing her any access. They actually have to work that out with the prison. She has to actually initiate that. So she's saying that, all of this, but she knows that she needs to do this. And that is something with her in the prison. You see, what's coming back to bite her and this is only some speculation on my part, but from what I've seen over the last couple of years, is that her interactions with the prison itself, with everybody there, is to now actually they've got a good read on her and it's actually interfering with her getting what she wants. She is not able to manipulate them the way she was. Exactly. In her mind, she did nothing wrong. But do you think that the state is going to offer her a plea? I mean, it would be her best option. I saw one of you say that. I know she wants a brand deal, but do you think the state, I think it's in their best interest. I'm going to say yes. If she could just get the judge to sit on the couch, he would see everything her way and throw out the case. Apparently. Yeah. Apparently. It just doesn't work that way. Isn't it a shame, Liam? She just can't get them to do that. It's just not going to happen. Okay. Well, so I do hope you'll take the time to check out the videos, look at the court hearings yourself. We'll do another update after tomorrow's hearing, whatever may happen and what hits the board. I would imagine next Tuesday we'll be talking about her again, along with there's some others. But I would like to ask you, I do want to do another one of these this week, either tomorrow or Thursday, much earlier than now. I don't want to interfere with shenanigans. It's got a great show about laws in Georgia and Texas and Florida, rather, not Texas, going on. And I don't want to interfere with that. And there's some other streams going on. But I do want to do another true crime because I've got a lot that I've been working and watching over the last 2 weeks here and there, you know. Which would you rather hear about? CoffeeZilla in Logan Paul or the Netflix baby reindeer suit about the stalker? I'm going to do one of them this week, and I will do the other one next week with Sarah Boone. So you're going to hear both. But tell me which one you're more interested in, and I hope you guys are okay with 7 o'clock, and we'll just do an hour. But come on, somebody say something. You're going to make me baby reindeer, Liam? Anybody else? Baby reindeer purple? Anybody else? You're going to let those two rule the world? Is your chance to get your voice heard. Okay. On that, it's going to be baby reindeer then. It's definitely, and I'm kind of excited. I've been following that one. I'm kind of excited to do it. So that will probably be Thursday at 7. I guess since I've been somewhat following the Logan Paul one, I'd say that one. I am going to do CoffeeZilla and Logan Paul because CoffeeZilla has finally responded and so much more happened to Logan Paul. Like it's lit. It's definitely going to be one all by itself for sure. Weird law in Florida where you can zip someone in a suitcase and leave them until they expire. Exactly. Me just do an hour mark. I know it is difficult, isn't it? But I do actually, when I do a second one, try to strive for that. And I think with baby reindeer, if I organize it enough tomorrow, I can do it in just an hour. It is pretty exciting. It's a very interesting case, actually. I like the ring of CoffeeZilla. I do too. I actually enjoy his content. And I've been following the case, and it's pretty ridiculous, and I can't wait to like bring it forward. We also have motions on Karen Reed and all. You know, they did have the motions hearing for the dropping of the charges, and they did do oral arguments, but I haven't seen anything from Judge Canone yet or anything more on that. So that's still on the plate too. And there's been a little bit in the Courtney Clenny case also. That I'm going to be put up. We got some stuff on DNA with Brian Kohlberger too. Like we got a lot in the upcoming weeks to go over. But we're going to have to stay on top of this Sarah Boone stuff because that trial is coming. And as long as it's available, we will be doing it live. Now, it is difficult to get a clean feed. As you'll notice in the 2 hearing videos that I posted, one is from Court TV. The other one's from Law and Crime. Law and Crime did not do one for the 9th because the audio was so bad. I think they just didn't put it out. They actually clipped just parts. There are 2. If you actually look for the ones on Law and Crime, there are 2 sections that are very clear, and they did it on 2 issues. But it was an hour and 47 minutes, and they did not put the whole thing out, which is why I gave you the Court TV one. And I do admit the audio is a little rough. They did not have microphones on the defendant. For her pro se attorney. They did not have the witness stand mic'd, but I think they realize that now, so that when they have hearings, I think they will be mic'd up. I think the area will be mic'd, and they may even put her at a table instead of in the jury box, since they're going to allow her hands to be free. But I don't know. We'll see. YouTuber runs scam. Other YouTuber calls him out. First YouTuber tries to hide their scummies behind a lawsuit. Exactly. And scummy YouTuber is getting sued by everybody. So like, hey, there's that. That's the case. That's the whole thing. Yeah. Logan Paul wants to say that somebody ruined his reputation, even though before CoffeeZilla even spoke on Logan Paul, his reputation was kind of trashy to begin with, which is why everybody just thinks he's a scammer. Because, in true honesty, like CryptoZoo is not his first crypto indulgement where a scam was indicated. Did anybody know any of the others? Pop quiz sometime next week. Anyway, thank you all for being here. I will be back on Thursday with some more true crime for Baby Reindeer. Look for that thumbnail. I'm going to have fun making that one later. And we will do that at the regular time of 7. I will be going back to 7. I just needed more time today to carry on for Tuesdays. Tuesdays will go back to being 7. Today was just extraordinary. And then for those of you that are interested, Friday, I'll be back with Mayhem. Yes, the first Mayhem of 2024. We haven't done a Mayhem since sometime in 2023. And I'm really looking forward to it. And we have some nice guests that are going to be there with me. And of course, Miss Mayhem, Mrs. Cassandra, she will be joining us. And several others. And I'll let you all know about that on Friday. So check out Baby Shark is what I heard. No, Baby Reindeer. Baby Reindeer, Mark. I'm not doing baby. Now that's going to be stuck in my head, Mark. But, that is better than the nightmare about Sarah Boone. So I guess I should thank you. So thanks, Mark. And thank you all for being here. And on that, I think I'm going to call it a night. Yeah, forgetting stuff about Logan Paul is good for your mental health. Sorry, I'm sorry, but we're going to have to do it. We're going to have to do it. Okay. All right. On that, let's say goodnight. Wait, start over. No, I'm not. Hit the replay. Hey, quiz, hit the replay. Hit the replay. I'll talk to you soon. I'll be talking to you in a few seconds, actually. Okay, everybody. Have a great night.